This week, the Constitutional Court ruled that foreign nationals who do not have permanent residency cannot be enrolled as legal practitioners in South Africa. SCALA-BRI-NI Centre, as a friend of the court and speaking for asylum seekers and refugees, is reviewing the judgment. In its ruling, the Apex Court did not find in favour of the applicants, nor did it make provision for a particular subset, and not even affirming the allowance for admission on non-practicing role. We're joined now by SCALA-BRI-NI Head of Advocacy, James Chapman. James, thank you very much for availing yourself this afternoon. Why was it so important that you actually avail yourself for this matter?
Greetings to you and to your listeners. It was crucial that we intervened and came on board with respect to this matter, because it is really important that people are able to practice law, and that in particular asylum seekers and refugees are able to practice law and defend, sometimes quite often marginalized and rights compromised asylum seekers and refugees, but other people as well. And so it was hoped, and also asylum seekers and refugees are in the country for a substantial period of time, and they can't return to their countries. So if you study law here or study law back home and you would like to practice law, you ought to, at least it was argued that one ought to be able to practice law here. But unfortunately, while we're still reviewing the judgment, it does appear that the Constitutional Court has said that, at least with respect to the provisions of the Legal Practice Act pertaining to admission, whether it's practicing or non-practicing, that is not feasible. It found that while there is discrimination, it's not unfair discrimination, and because it's not unfair, they didn't need to go on to the justifiability of it.
What is the consequence for those who are already practicing?
It's if you have already been admitted to practice law, then one will be able to continue. But anybody who is yet to be admitted, whether it's to be admitted as an attorney or as a notary or a conveyancer, if you've written those exams, you won't be able to be admitted as a result of the finding.
For one to fully appreciate whether this is a progressive or regressive move, maybe just help us understand what we're seeing in other countries and whether South Africa is the exception to the rule here.
Well, I mean, other jurisdictions do apply the law differently. There's certain jurisdictions that allow foreign nationals to practice law, or at least a subset of foreign nationals. For example, those that are recognized refugees. There are other jurisdictions where you're a recognized refugee for a very short period of time before you become a permanent resident and then a citizen thereafter. And so a provision like the provision that was being questioned here, where it says, you can be enrolled as a legal practitioner if you're a South African citizen or permanent resident, in such jurisdictions would be very straightforward. But in South Africa, where you can, for a number of years, be an asylum seeker, and then 10 years further as a recognized refugee, before you can apply for permanent residence, there's an enormously long period where you wouldn't be eligible to be enrolled as a legal practitioner admitted. What the Constitutional Court did say, which I suppose is a slight kind of silver lining, is that there isn't the employability in different capacities that don't require admission as a legal practitioner are not curtailed by Section 24(2)(b) of the Legal Practice Act. And so as such,